Hey guys, it's Kathy. I hope you're doing well. Thank you all for sticking with me through that nightmare of a live stream or 2 live streams this morning when my computer just crashed. So I'm doing this on my crappy old laptop, just like the old days. So I thought I would do it real like the old days. Okay, so when I started making videos, when I would get a video, I would go searching for more information. And I did it today, guys. I went searching, I went digging for more information. So before we see this guy, I'm going to show you what I have for more information, but I'm missing a video. Hold on, let's try this one. Okay, we're going to get to that. Okay, so I'm going to rewind it back to the beginning. So we got this guy in court in Indiana today. And so when I first started recording, I had missed the part where the judge was saying that the motions he filed to criminally charge the city and the courts and the police officers were denied because he doesn't have the power, this defendant, doesn't have the power to prosecute anyone. He wanted the courts, the police officer, and everybody charged criminally. And of course, it was denied. So he's going through this hearing today. Now, this hearing gets a little dry at the beginning for the first, 10, 15 minutes. It's a little dry. It's all lawyer. There's a little bit. His bond argument is superb. And the judge that we see today, he only takes in information that applies to the case, and he only outputs information that applies to the case. He's like a robot. So he'll let someone go through their crazy all they want, but he's not going to stop them. He's not going to hold them in contempt. He's not going to mute them within reason. He's just going to take in information that applies to the case and then keep going from there. So this guy, he gives this guy to make a chance to make a bond argument and complain about attorneys and things like that. This guy has some serious anger issues. I'm telling you. As I'm digging, you'll see. So what I'm showing you now is just what I found of his criminal history. So it started in 2002 when he didn't have his seatbelt on. That's a gateway crime. It's a gateway crime when you don't wear your seatbelt. And then Joey, that's not him, so we're not going to worry about that. So this was 2002. Then he behaved himself until 2017, and then nothing really. It was just a replacement title. So he's still behaving himself a little bit. So in 2020, COVID hit, and then everything goes downhill from here. This guy, okay. So again, not that bad. Disregarding an official traffic control device in January of 2020. Then in March 2020, we begin. Criminal trespass, disorderly conduct, unreasonable noise. So that was in March. And then again in March, that was March 6th. And then on March 19th, criminal trespass. And then I think in May, I'm just scrolling so slow. Come on, let's go, hurry up. There we go. I recorded my scrolling. So April, domestic relations issue. And then in May, criminal trespass, unreasonable noise. And then here, I'm gonna pause this for a second. the worst crime of all. This makes him guilty for every other crime in my eyes. So in November 30th, right before Christmas, Thanksgiving, everybody's out driving, trying to get stuff done. Everybody's out traveling. There he is, driving at reduced speed in the left lane, traveling in the left lane below the speed. How dare he? So then in July of 22, it's just a civil collections. He owed money. Okay. Then breaking and entering in August of 2022. Then in September, criminal trespass again. And in September, calling 911 for no reason. And then he sues the town of Bourbon, Indiana, but he also sues two people, I think, that work for, there are two council members, or a council member and a clerk. I know he sued two other people on top of the town of Bourbon, Indiana. And it was about a bicycle, and that's all I know. I don't know what happened to the bicycle, but it was about a bicycle. But it was a long case. So, he kept filing motions, and then there was a jury trial set up, and then he had to cancel that. Then there was another jury trial set up, and everybody had their witnesses. The jury came in, and he never showed up. So the judge dismissed it with prejudice, so he can never come back and talk about this bicycle again. The judge said that he had ample opportunity and didn't show up, so that's over. So now we get into criminal mischief. Disorderly conduct engages in fighting and tumultuous conduct, and that was in July of 2023. And then again, a few days later in July, criminal mischief. And then in August, resisting law enforcement, disorderly conduct, engaged in fighting. That was in August of 2023. And then November 2023, we're going to get into this one in a second. So just remember this. This was an appeal. He appealed one of the cases that he lost. And then we have this felony 6, battery against a public safety official. That's what we're going to see the video on today. Resisting law enforcement and criminal trespass. Okay, that's what we're going to go through today. But then he also has another one that's still pending for criminal mischief. Okay, so let's go to the appeal. Let's look at this appeal. That's the wrong video. There's the appeal. So it starts with he goes to the bank on July 3rd, and while passing a hose without breaking stride, he reached down in its direction. The spigot was not visible. The hose had not moved. He can be seen walking past the area when he leaves the bank. Okay? So what happened was the bank manager came back. This was right before the 4th of July holiday. So when the bank manager came back after the 4th of July holiday was over, which was a 3-day weekend, the bank was flooded. The crawl space was flooded. There was damage. I mean, the vault's okay. Everything else is okay. It was just some stuff in the bank and landscaping that was completely flooded. So they had this video in the court. They went to trial. It was jury trial. The video shows no one going near the spigot at all, except for him. And they saw him sort of pause, dip toward the spigot as he walked by. Okay? And then he was found guilty. And he was sentenced to, I think he was sentenced to 180 days with 88 suspended. And then in October, he was put on probation, and then he was ordered to pay $150 for a fine, court costs of $180, and $860 to the bank. All right, so he appealed this. He appealed this because no one ever asked if he was able to pay any of this money. All right, so let me keep the video going because I have the decision from the Court of Appeals as soon as I scroll down. Second now. Says state did not prove beyond a reasonable doubt that he actually turned the water on. They just showed that he was near it, but he didn't turn the water on. Now, when we get to the Court of Appeals paper, you'll see why. Okay, here we go. So, this is the Court of Appeals letter. On July 3rd, the bank manager took a call from an employee at customer service call center. She was informed that Lemler, that's his name, had called a number of times and appeared to be upset and erratic. And he was on his way to the bank to close his account. So, as soon as she found that out, she began to review his account history. She didn't get through it because she was interrupted by an employee reporting that he was on his bicycle in the car lane outside, where he started hitting the call button, screaming and unleashing profanities. So she approached the drive-up window and asked how she could help. He said he wanted to close his account, but his profanity escalated. So she called the police to escort him from the credit union property so she could focus on getting his account closed. Later that afternoon, Owens called and left a voicemail indicating that he needed to come back to the credit union and negotiate the check that had been drafted to close out his account. He called to verify he had permission to return. Now, she said, you can come back, but you have to be calm. So right before 4 o'clock, when banks closed, he got off his bicycle across the street, and as soon as he approached the teller window, he began beating on the equipment with his fist. So Owens, got the check out to him. He endorsed the check. He got his money, and he left the property walking on the far side of the building. And then the employees left for the 4th of July holiday, and nobody noticed anything. When she returned on July 5th, she noticed the pavement was wet. After she exited her vehicle, she saw water coming from the spigot on the south side of the building. And the landscaping was 6 inches of water standing in the lower window wells. So she called the security officer, and the crawl space was saturated. So they had to rent those big dehumidifiers and fans to dry it out. So they had the camera installed, and that's where they found out that he dipped as he walked past the water spigot. And he was charged with criminal mischief. They played the video in court, in jury, and he was found guilty. So he was ordered to 180 days with 106 days executed and the balance suspended to probation. And then he was fined. So the decision I'm just going to tell you what the decision is instead of waiting for me to scroll again. So they did find him guilty. So one of the things in the appeals was that the bank did not prove that he created the water damage. Well, the appeals people said that's not true. You did it. You were found guilty. But they did, in fact, say that they did not see if he's able to pay. So they had no indigency hearing. So what they said was that they have to have an indigency hearing to see if he can pay these. So he sort of won the appeal and lost the appeal. Okay, so that's where we're at. All right, so he's still going on with that. Now, he says something in this court that I don't quite understand. He says that They're talking about bond, and you'll hear it coming up. They're talking about bond, and he says that he has a vested interest in $8,000 from the city, but listen, I don't know what it is. I can't find anything about it. I looked and looked and looked. So I'm just as dumbfounded as you are about that part. So, like I said, it starts out dry. It does. It starts out all law talk and dry. And he behaves himself. And then he has a superb bond argument that I love. I just love it. And then when the judge says all he has to say, and he says, do you have any more questions? And then well, no, it's before that. When he finds out about his attorney, things go sideways. And before I do that, I want to tell you about his attorney, what I found out about his attorney. Okay, so we're just going to scroll up a little bit here. So this disorderly conduct, that's not it. Chipman was his attorney. I'll wait until we get to Stanko. Stanko was his attorney for a lot of his later cases. Looking for the attorney. Nope, still Chipman. Chipman. Johnson. All right, so there. He has, in 2023, he finally got Stanko. Stanko was his attorney. That's still pending. So we don't have an answer on that yet. And then I skipped some. Look, I don't know where this is right now, but I will tell you, he had 2 cases with Stanko in this long list that Stanko got completely dismissed. We saw this trespassing, disorderly conduct. 2 of them, Stanko got completely dismissed. So, he should be thanking him, but anyway. Let's get to the court case.
Moving into the hearing dates that we're going to schedule. This is what's on the initial hearing order. There's a first pretrial conference, and that pretrial conference is August 14, 2024 at 9 o'clock. If you have an attorney on that date, the attorney will be here on your behalf. If you do not have an attorney, or you're still working to hire an attorney, then you must be here with me. And if you're incarcerated, we will bring you here via the jail video. The status hearing is...
I don't understand that part, because he definitely has a court-appointed attorney assigned to him right now. And the judge doesn't know this. I don't know how the judge doesn't realize this.
October 17th, 2024. That is at 8:15 if you're incarcerated and 9 o'clock if you are released. That is a mandatory day where you must be here. Regardless of what is occurring in the case, plan on being here at that status hearing. You understand that you have a mandatory obligation to be here at that status hearing?
Yes, sir.
The final date that is noted is the omnibus day. Your omnibus day will be September 4th, 2024. An omnibus day is a date in the future by which certain deadlines are established. It is not a formal hearing date, so you don't need to plan on being here in court. However, it is a date that is approaching, and so therefore the corresponding deadlines are approaching as well. Ensure that you follow up with your attorney and or have any documents, motions filed that need to be filed by that. I can't give you details in regard to what motions must be filed by corresponding deadlines with the omnibus day, because that would be legal advice, but that is why it's important for you to speak to an attorney early. Additionally, because you referenced that you'd like to hire an attorney, and I'd like to follow up on your ability to hire the attorney, I'm going to schedule a status of counsel hearing, and that status of counsel hearing will be in 1 week, well, slightly less than 1 week, I should say. That will be scheduled for June 5th, 2024 at 8:15. Again, that's next Wednesday. And the status of counsel hearing will be for us to follow up on your ability to hire the attorney, certainly whether you've been able to make the phone calls that you've referenced and requested. And so I can address no later than June 5th what your ability to hire the attorney might be. One note about that hearing is that if you post bond and you are released, you have no obligation to be here at the court. The only place and time that that hearing will occur is if you're still incarcerated at the jail and have not been out to hire the attorney. Any questions over that status of counsel hearing, sir?
No, sir.
Now, you referenced your bond earlier. And
So far, so
held on
good.
that bond. Bond set the amount of $5,000 after the court reviewed an affidavit of probable cause and entered an order finding probable cause and then setting that bond. The pretrial release recommendation in your case was filed, and it notes that you have 0 past failures to appear. It notes also that you are disqualified or not eligible for pretrial release because of the offense being charged, which is battery against a public safety official. What that means is that anyone that has been charged with that type of offense falls into a category of offense that excludes pretrial release supervision. So therefore, we then defer to a bond setting. I believe you had some requests in terms of your bond. You began to talk about it, and then I let you know that we'd speak about your bond.
He sure
Mr. Lemler,
does.
to give you an idea, state to see if they have any recommendation on bond, and then I'll come back to you to hear any recommendation on bond that you have. Mr. Aldridge, what's the state's recommendation on bond?
Yes, Your Honor. As you noted in the pretrial release recommendation, he is disqualified from pretrial release. And therefore, the state would defer to the court. The state believes that the court setting of bond in the probable cause order is appropriate and would ask that the bond remain in that amount. Thank you.
Thank you, Mr. Aldridge. Mr. Lemler, what was your request in terms of bond?
Well, I will say this, sir. As you well know, I have before I was incarcerated in your court, I have made a request against the city of Bourbon, Indiana, for a set amount of $8,125.
I can't.
I don't know the outcome of that because I was incarcerated. So I have a vested interest in staying within the county. I have no reason to leave here. I have every reason to fight everything that's against me. I believe because of my status of financial status and the fact that I have no reason not to leave this county for any reason against anyone in any case that I wish to defend. I believe my bond should be reasonably what I could afford to bond.
Don't come to Pennsylvania.
And $5,000 is not reasonable for me. So I would say, I'll tell you this, sir. So right now, I retire. I'm officially retiring on my birthday, July 11th, 2024 this year.
Congratulations.
Currently, I receive a pension from Pioneer Hybrid of $160 a month. And I have HIP and I have food stamps. That's it. So, as far as other, here's another thing that I do have available to me right now. I also have another pension fund from Land O'Lakes Purina Mills of $12,000. But I can't get access to it because I can't even get access to my power of attorney, which is Joseph Frederick Lemler. So I would say at this point, make my bond $160. Yes, because right now on June the 1st, my check is automatically deposited in my bank account here at Centier Bank on June the 1st for $146 and some odd change. I can pay that.
As I heard it, your request was to lower your bond and specifically to lower your bond to $160. Did I hear that correct?
Well, I said I misspoke. My pension check is $160, but after taxes, it goes down to $146. So the bond, correct, $146.
$46 to be the bond.
Correct. Or actually zero bond, because then I have nothing to live on.
Essentially, you're asking to be released on your own recognizance, correct?
That is
long way.
correct.
The long way.
Because I have, like I said, again, I have no vested interest of not showing up in court and fighting this.
Thank you. Mr. Aldridge, any response from the state?
No, Your Honor.
Now, Mr. Lemler, you have outlined reasons why you believe that a reduction of bond and or release on your own recognizance is relevant. You have made substantial discussion over your ability to post bond. The statute requiring the court to set bond and then giving factors to consider in setting bond outlines ability to pay as one of those factors. But it is just that, one of many factors. Now, you do have strong ties to the community, and indication of that you have said you will appear at all future hearing dates. You have somewhat unstable living arrangement, but you've indicated that you've been residing in this community for a while. And so therefore your strong ties to the community increase your chance of appearance at future hearing dates. Those two things are the favorable circumstances. The unfavorable circumstances, and these are factors again that I'm considering, are the nature of the offense, the fact that there is another pending case, the level of offense being a 6 felony, and the general safety in the sense of it's a battery offense. When I weigh those factors, I think that the bond is appropriate. And so your request to lower the bond and or be released will be denied this morning. You can reiterate that request through an attorney, or if you represent yourself, through a formal motion. This morning, the bond will stay at $5,000 cash. Any questions over that, sir?
No, sir.
But his anger
I'd like
is
to hear a
rising.
little bit from the sheriff's department because I'm trying to verify the nature of the phone call issue. So Crawford, has he been removed from the list, placed on a list, not allowing him to use any of the jail communications?
No, sir. Judge Colvin asked that we give him a phone call yesterday, and that was done at the booking desk.
So he was able to make one phone call to your knowledge from the booking area, correct?
I believe he made 2. Yes, sir. He has access to a phone where he's housed. While in booking, he was not given his initial phone call.
And where he is currently treated, presume that is done through the jail communication system, where there has to be money placed on a certain book to place those phone calls. Is that all correct?
Yes, sir.
And certain phone calls are free, and those may be to attorneys' offices if they're honored or registered. Is that also correct?
Yes, sir.
So, Mr. Lemler, I've heard some information from Taylor Crawford. I think that some additional time, I know Judge Colvin handled this yesterday, had told the Sheriff's Department certain things. It's now been 1 day. So I would continue to try to make those phone calls. And if someone can place a certain monetary amount on your account so that you can make those phone calls to non-attorneys or the non-free calls, that may assist you in making the phone calls. To put it differently, the Sheriff's Department authorizes the use of phones, but it doesn't do so at a free basis unless that's for legal purposes such as talking to an attorney. And again, that does not include powers of attorney. That just includes attorneys of law.
Don't
Now, I will follow up on that on the 5th to ensure that you've been able to make those phone calls to try to assist with hiring the attorney, and or you can reiterate a request for a public defender on that June 5th hearing date. Any questions over the information we've covered this morning, sir?
Yes, sir. So what Mr. Crawford said is inaccurate. Mr. Diltz made those phone calls. I did not.
That's
When
not
the defense, this is what he put in front of my face today, Mr. Crawford. It says, maybe you have this document, I don't know. The defendant appeared in open court for the purpose of an initial hearing. At that time, the defendant indicated he would like to speak to an attorney named Ruth Johnson, who previously presented him in an appeal in case number 50D022307CM-671. At that time, the court directed the Marshall County Jail staff to allow the defendant to make contact with the attorney to see if she would be willing to represent the defendant in this manner. The jail staff connected the court saying the defendant tried to call the attorney. I didn't try to call, they did. And the first number he called was not correct. I didn't know that because I didn't make the call. The defendant called the second number and left a message and then was returned to his cell. I did not do that. I was not on the phone. I did not talk to the woman. The jail staff located another phone number and spoke to the attorney Johnson, who informed the staff that she is an appellate attorney and will not be representing the defendant in case number 05D02240CM-588. Having already questioned the defendant about his ability to hire an attorney, the court now appoints Paul Stanko as a public defense. This is the first time that I've heard that from the judge. And Mr. Stanko is not acceptable because he's not acceptable to me because of prior cases that he's handled, that he has failed to handle properly.
You were found guilty.
That's all I have to say.
First off, none of that was responsive to my question. Second off, I'm not appointing Mr. Stanko in this case. Do you have any questions?
Okay, so right now, sir, I'll tell you this right now. I have no means to hire an attorney, and Mr. Stanko is not an option. Now that I know that Ruth Johnson is not going to be available to me.
Would you like?
So there's no need to wait until June the 5th.
Would you like to wait until June the 5th to try to?
No. I want a point-of-court attorney, and whoever it is, it better be an incompetent person like Mr. Paul Stanko.
You would like
He never returned any of my calls. Never.
I'm going to remind you, I'm giving you the opportunity for, you must not interrupt me. Now that's the second time that I've had to remind you of that. Do you understand you are not to interrupt me?
Yes.
You've made a request for a public defender. You mentioned you don't have any funds to hire an attorney. You've outlined certain details related to your finances such that you do not have a physical residence you own. You receive a nominal amount of pension in the amount approximately of $146 per month. Am I correct in saying you don't have any other income other than that pension?
He sells breathing.
Well, at any given time, if I was to be able to make an outside call, I would have access to $12,000.
So you have a lump sum of $12,000.
I'm not sure, sir. What happened was when I last April, I contacted the Social Security to engage my retirement for when I turned 62 on July 11th of 2024. They wrote me a letter back stating that they have found pension money that I wasn't aware of the sum of $12,000 through Land O'Lakes Purina Mills. Before I was incarcerated, I did contact them, and they said within 10 to 12 business days, they would have the information for me to either collect that money as a lump sum or over time. This was back in April. I've been waiting for that correspondence in mail at my mailing address at 510 West Adams Street, Suite 210. And one thing that I would do if I can, if I'm allowed to access my power of attorney, Joey, is to have him get that and process it so I can have access to that money. That's the only other income I have at this point until I retire on September the 17th. I will receive retirement funds amounting to $2,200 a month for Social Security. But at this time, I have zero.
Thank you for that information. You have some asset, but you currently do not have access to dollars. You anticipate possibly having access to that in the future, but as of now, you do not. Based on that information and based on prior determinations of indigency, I will find that you qualify for the appointment of a public defender. I'll appoint Alex Hoover to represent you in this case. I will note for the record that that is different than your attorney in the Superior 2 matter, which you referenced, but I did not address because I am not, in fact, in Superior 2. In this case, Mr. Hoover will be representing you. Any questions over his representation?
Yes, Mr. Hoover is a conflict of interest because I have a case against the town of Bourbon, Indiana, and he is their attorney.
Thank you for raising that, Mr. Lemler. I apologize for forgetting that he represents the town of Bourbon, which is the claim that you referenced earlier. So I will formally not appoint Mr. Hoover, and I'll appoint Ms. Buells, June Buells, to represent you.
She is not acceptable either because...
Hold on, before we find out why she's not acceptable, we did see that case against the town of Bourbon about his bicycle. And it is absolutely, trust me, I read the whole case. It was dismissed with prejudice, which means he cannot bring it up again. So I don't think there's a conflict of interest anymore.
Of a previous case that she mishandled, the court had to apologize for her misdirection in Mr. Colvin's court. And she represented me in a prior case. That was back in 2022.
I will allow Ms. Buells to notify the court if she believes there's a conflict. However, Ms. Buells' appointment will stand. I'll vacate the June 5th, 2024 hearing because that purpose was to check on the status of counsel. Now that you have counsel, there's no need for that hearing. So the hearing dates will be the pretrial conference of August 14th, 2024, which currently Ms. Buells will be here. The status hearing of October 17th will be a date for you to check back on the status of the case. Any questions over that information, sir?
That particular information, no. I have other questions, though.
What does it relate to?
It relates to my ability to make a phone call outside these walls of this building and having them approved by what I was told Mr. or Chief Jailer, whatever his title is, Ryan Shorey. I was told ever since last Friday, before the holidays, that he was going to do that. Then the holiday came. Then he was sick on Monday. Then yesterday he wasn't available. And then this goes on the next day. And I still am not able to call out of this facility or make contacts with emails to my son, Joey Lemler. How is that possible, sir?
This is not the time for you to ask that question of how it's possible or not. I have addressed that with the jail. You've been sitting here the entire time, and so I do not know, or do you know, whether that is currently the ability that you can call or not. Since I addressed it with the jail, you've been sitting here the entire time. So that's not really responsive to the question about the information about the initial hearing. There are administrative policies for you to go through at the jail, and I encourage you to do so.
I have, sir. And this gentleman in the back here, Mr. Crawford, is not allowing it to happen, or Mr. Diltz. So what is my recourse? I have no idea. And they also do not allow communications to the court through my venue. So I've written letters to the court, Colvin, not to your court at this time, but I will.
Please speak to Ms. Buells about that. She can advise you further.
When will I see her?
I do not know.
I don't either.
Keep her scheduled, sir.
I don't know what either. Then another problem is I will be given a phone call to her and it will say, oh, you can't make a phone call to her now because I I don't even know the hours of time I can call her. And when they are available, they say, too bad for you, Mr. Lemler, because we're on lockdown or you've already used your timeout. I have no idea how to get out of this hellhole, sir. I have no idea.
Your bond is $5,000 cash. That's the mechanism to be released. I don't hear any other questions. You've gone on about other matters unrelated to this criminal case or at best ancillary to related. So I'm going to conclude today's initial hearing. You have your hearing dates. Ms. Buell is your attorney. I encourage you to speak with her. Thank you.
If I am able to, I will, sir.
Thank you, sir. Thank you for the jail staff as well.
The judge is about to smile, guys. Be ready. That's not normal from him. I didn't know he could do that. Okay. Now this next one we're going to. I don't remember what state it's in. I'm pretty sure it's either Indiana or Colorado. So I narrowed it down to those two. It's a new judge to us. We've never seen her before. So I don't know what state she's in. There's a little tiny itsy bitsy little icon at the top of the screen that I guess we could find out, but I can't see it. I can't see that little icon. But I'm going to try to figure it out because I want to follow this case if possible. So, just so you know, audio issues. We're about to run into audio issues. We don't understand what she's saying. We can sort of hear her a little bit. We can sort of read her lips. But the judge is going to translate for us. Don't worry. The judge got our back. This woman has some issues. And crocodile tears right out of the gate. And they're so fake. Wait till you see. You'll see. Here we go.
I'm sorry, Judge, I cannot hear a thing.
All right, Miss Miller, I apologize. But what I believed I heard was that you were trying to write the court.
I 8-page letter 2 years ago.
I got a letter about 2 years ago telling me that I was not allowed to submit report. That anything that I would submit would be
Is she sleeping while crying?
All right, so what I think I heard, Ms. Miller, just to make sure that this is what you said, that you wrote me a letter about 2 years ago, and that I told you I was disregarding it.
I got typed letter that that was submitted would be discarded, that I was not allowed to submit anything to you, but I had wrote you an 8-page plus letter explaining to you the circumstances.
Did you have an attorney at the time?
Maybe.
And that is, if that was my response, you probably had an attorney, ma'am. And so the court does not allow bifurcated representation. So if you had an attorney, that information should have gone to your attorney and the attorney would have filed it with the court. Now, if you're unrepresented, then you can send me correspondence. So, but the thing we're here for today is determining this child support issue. Do you have documentation somewhere?
Yes.
All right, so, what I'm going to do, Miss Miller, I guess, Miss Littlefield, is there anything else you want to say?
Now I understand that she said that she hasn't received any payments. What I would like to know is what will the payments be? Because if she has been determined to be disabled, she would know what the payments are.
It would be, I just submit the paperwork as soon as I can get out what they said to me.
Do you have like a ballpark figure that you read on the paperwork? It doesn't have to be exact.
No, I don't remember. But I do have the paperwork. So as soon as I'm able to get out, submit it to you guys of what they sent it to me.
All right, so this is what I'm going to do, Ms. Calhoun. I'm assuming everything you said to me today is true.
Yes.
So I'm going to release you from custody.
Thank you.
I'm going to give you 7 days from today to provide a copy of the paperwork that you received from Social Security indicating that you are getting benefits.
Okay.
And you have 7 days to file. Actually, it might have confidential information, so I want you to send it to Miss Littlefield and to the prosecutor's office, the 4D division, to Miss Muir. And you can drop that information off at Miss Littlefield's office. She's here in Goshen. And the prosecutor's office is located in Elkhart. So you got 7 days to do that.
Okay.
I'm gonna set it for a review hearing to make sure that this part of the process is done. Because hopefully, Ms. Miller, with your disability, that will alleviate the issue of child support payment. Because it will be taken, it will be sent directly to the father through the federal government. So it looks like I have June 28th available.
I cannot do that, Judge. But here's what I would ask.
Okay.
Because we are, and I'm not trying to buck the system here, but we never get her back into court unless we do body attachments and incur more fees. So if you're requiring her to provide documentation in 7 days, can we have the hearing next week? Because that would be 7 days.
Sure. Let me see. I think I can. Yes, that would be June 7th.
Okay, that I would appreciate that, Your Honor.
All right. So,
Your Honor, if I may,
yes.
two of our deputies, me and one other, will be at conference next week. I can see if maybe Mr. Williams can cover since he's not going. But if not, that'll be our reason for not being there. But hopefully I can get coverage if that's the date you select.
Yes, so we're going to do it June 7th at 9:15 a.m. And ma'am, I need you to be here in Goshen to so that we can move this case along. And if Miss Littlefield, after reviewing those documents, has any questions for you or needs any other information, that we can move this process along. So your cooperation with this is going to be integral. And I will tell you now that if you fail to appear at the hearing on this June 7th, and you have not provided the documentation, I will issue a warrant for your arrest again, because I'm telling you now, in court, and that'll be considered a direct contempt if you fail to appear. You understand that, ma'am?
Yes.
All right. So I'm setting it for June 7th at 9:15 a.m. in the courthouse in Goshen. So Miss Littlefield and the state of Indiana, the 4D, should have already received all of those documentations. Whatever letters you have, just make copies of them and give them to those two people. You understand what I expect of you?
Yes.
And you understand what will happen if you don't do what I tell you to do?
Yes. Set release today. I've got 7 days from today to get the paperwork to you guys.
She has no paperwork.
Right. So that would mean by 9 o'clock, that paperwork has to be distributed.
Okay.
Next Friday, the 7th.
Your Honor, I do have one question. I noticed that when I looked up Ms. Miller's holds, that there were a couple of them. There were a couple of bonds. Would this have been the last hold you had, Ms. Miller?
Of course. Once everything is figured out and we think it's over and we can move on with our lives, nope.
I'm sorry.
Are you being held on any other pending charge as for bond?
What's going on with my students? And that's, you know, honestly, like I said, there's a lot going on that you guys aren't aware of. So.
Ms. Miller, I couldn't hear you. Are you being held on any other bond right now?
I don't think so.
I'm sorry, ma'am, did you say I don't think so?
No, I don't have a bond or anything.
Do you have any other holds, like does any of you owe anybody else money? Do you have a criminal charge?
Maybe.
But no, I don't have anything. Just,
She did have new criminal charges. I think they were driving, Judge, but I don't know if that's still current.
Let me see, you know what, hang on, I might have, no, this is all, let me stick her name into the system and see what else I get. So hold on just a second, let me go to a different program. If it's in Elkhart County, I might be able to find it.
The ones that I saw were.
Ma'am, what was your middle initial? I'm sorry? M? Yes. So it's Caroline M. Miller?
Her tears left pretty quickly.
Are you have a charge out of Superior Court 1, ma'am?
Absolutely, yes.
And it looks like there's a warrant that was served? What was the warrant?
Absolutely, yes.
What's the issue?
we're on the 10th.
No. You had a driving while license suspended?
Yeah.
And is there a court date on there?
10th.
1:30, let me see.
Looks like you have a court date of June 10th at 1:30. So you may not be out by next week.
Well, then, Judge, I guess what I would suggest then is to push it back another week.
All right, so let's do June 14th then. But I guess we need to find out when I don't know what's going to happen on the 10th because I'm not the judge in it, so.
She's got three warrants
3 warrants?
for the same day.
Oh, for the same day. 3 different cause numbers?
Yes.
All right, so ma'am, it looks like you have 3 different cause numbers, but they're all in Superior Court 1. So hopefully all of your cases will be resolved. Does she have a public defender?
I think it's a new case.
Oh. My court reporter is quicker at looking stuff up than I am.
Is my public defender for that?
Warren Murphy, that was no, that's not.
Warren Murphy? He's an attorney.
Well, I mean, he's not in England.
Oh.
Okay. So, when the gate was happening.
All right, so I guess we'll stay tuned. You want to write down those cause numbers? And that way, so, and I guess, Ms. Littlefield, if you want me to give you those cause numbers also.
I can look them up, Judge. I looked it up before, so.
All right, so, we'll tentatively put it for the June 14th at 9:00 a.m. That'll probably make it easier for the
That's not good
prosecutor's
for the
office since they
defense
are at a
attorney.
seminar.
So then, what is that for days to be able to get everything, because I don't have a vehicle, so that means I'm gonna have to walk from Elkhart to Goshen. It takes me well over 5 hours just to walk.
Okay, so what she's saying is she has some paperwork that she has to turn in, saying that she's disabled and she's going to receive Social Security payments. All right. And if that happens, then they can take that money for child support directly from that and send it directly to the father without her being involved at all to pay child support. Well, the judge said because there's personal identifying information and sensitive information in documents like that, she can't submit the paperwork to the court. She has to drop the paperwork off in 2 different counties for a public defender and the prosecutor. They're in 2 different counties, okay? And she's saying, well, how am I supposed to, in 4 days, get paperwork to both of these places?
I'm sorry, ma'am, I couldn't hear you.
Right, so it's 4 days gonna be enough, because I don't wanna put myself in a fatal situation where I'm in her again.
Well,
So,
ma'am, you're just gonna have to get it done. So you got 4 days. If you're released on the 10th, then you've got 4 days to find your paperwork and get it distributed. Otherwise, you will, either way, you will be here on June 14th. And thank you.
She doesn't have paperwork.
I'm going to go ahead and release you on today with your promise to appear on June 14th.
yes.
Same things apply. If you fail to appear, I'm telling you now, you are to be here in person in my courtroom on June 14th at 9:00 a.m.
So before they said something about a body attachment, she said, Littlefield said, we can't get her to court unless she has a body attachment. Is that like a GPS? Because she's not coming. She doesn't have paperwork. She's not coming to court. Is there such thing as a mind attachment? Maybe. Let's try that one.
If you fail to appear, I'll issue a warrant for your arrest. All right. Anything else that we need to discuss today?
Oh, Your Honor, thank you.
Thank
All
you.
right. All right, I'll see you all on the 14th. Thank you.
Thank you.
Bye.
I would like to know what's in that 8-page letter, though. You can just imagine. You can just imagine the craziness that's involved in that 8-page letter. I wonder if I write a letter to her, if she will send me a copy. No, we don't. We never reach out to people that we see here. Never, 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 never. Never. All right, guys. I hope this went better. I haven't heard it yet. I'm going to play it back before I upload it to see if the sound is anywhere close to acceptable. Who knows on this laptop. But I hope this went better than the stream. Thank you so much for coming out today. I really appreciate it. And I will talk to you later. Bye, guys.